मनमानी तो नहीं चल सकती है, कोई भी कभी भी चाहिए बंद करे और वर्कर्स को बाहर फेंक दे। कैसे जिएंगे वो, कैसे उनके बच्चों को शिक्षा और घर का भाड़ा भी दे देंगे, ये सवाल है। तो इन्होंने क्यों किया, ये तो इनके एनुअल रिपोर्ट से ही साबित होता है। मैं कह रही हूँ कि इनको पल्प, रियल एस्टेट और इस सब के द्वारा जो crores of rupees they were earning, but they were showing that they were in losses, and that's why I wanted to hand over that extra document. But without that also I can say that that can be followed by anyone. But 25O जो है, that requires that the permission of the state government needs to be obtained, and while giving permission, the state government has to give a hearing to the workers. It is the state amendment for section 25O, where the procedure for closing down an undertaking is elaborated in the Madhya Pradesh amendment. An employer who intends to close down an undertaking of an industrial establishment to which this chapter applies shall apply for prior permission at least 90 days before the date on which the intended closure is to become effective to the state government, stating clearly the reasons for the intended closure of the undertaking, and a copy of such application shall also be served simultaneously on the representatives of the workmen by registered post with acknowledgement due. Then the decision by the state government is to be taken according to this. I will not need not read out the whole thing. Is to be based on the criterion as to whether the public purpose is going to be served. Now, if employment, source of livelihood, is not a public purpose, what is the public purpose in this country? My lord, that's why this process they never followed. And the High Court, therefore, in their order said that the wages need to be paid. So the tribunal's order was endorsed by the High Court. That is my point. Now, and this is the tribunal's, this thing was as far as restraint of entry into page 269, para 29. In the same order of 6th February 2019, which I was reading. As far as restraint of entry into factory premises of workmen is concerned, when we go through the reply of opponents numbers 1 and 2 from the analysis, we can easily gather that opponent numbers 1 and 2, that is the two companies, have pleaded that units have become sick and unviable. Therefore, they are unable to run and operate units and continue to provide employment to workmen. So they themselves have clearly stated that the units were closed down. And that is there in number of documents. I will just refer to 1 or 2 documents. But to continue, in other words, they are going to close the units without adopting due course under section 25O of the ID Act. In these circumstances, still adopting due course of law, opponent numbers 1 and 2 should run and operate units, and they cannot be allowed to close down the same. Consequently, opponents are directed to allow workmen to enter into the factory premises and allow them to work. They are further directed to pay remaining amount of wages. That point of time, it was the payment that was pending from October 2017 to December 2017. But they did not follow this process under 25O, and they kept the mills closed. Now, that is proved also by another judgment of this Honorable High Court in 2248 by 2019, because against this order of the tribunal, the company went to the Century, approached the High Court and filed an appeal. Now, that High Court in this order 2248 by 2019 took a decision which was a balanced one and in between. It thought that the tribunal has erred in not taking into account that the plant and machinery that is more than 22 years old and lying shut for more than 1.5 years if operated, will pose a huge safety risk and has substituted its own views in place of the good and practical sense of the petitioner in violation of the fundamental rights of the petitioner, not of the workers. Now, but
page number, you are reading page number?
284. Sorry.
284.
Yes.
Para
6.7. Now,
this must be they are pleading, I believe, 6.7.
Pardon?
Page number 284.
Yes.
It is their pleading or it is a part of the order?
No, it is part of the order.
Pleading. Pleading.
It is part of the order. It is the.
Page 95 is the operating.
Sorry, it is their pleading. So they themselves have agreed that but they were saying that machinery is such that they cannot run the mills. Now with this, the order came to page 287 is of the 25th of November 2019. Again, it reiterated the same thing in para 8, page 289. It has been stated that the plant and machinery is 22 years old and lie closed for 2 years. If the plant is made operational, it will pose a huge safety risk to the workmen. It has been stated that since the petitioners are paying wages to the workmen, there is no change in the service conditions, and therefore impugned order deserves to be quashed. So they quashed the 2 paragraphs which I earlier read out, which according to which are also quoted on page 291, saying that the mill should be opened and the employment should be provided. So in spite of this, what the High Court's order of that date, 25th November 2019, concluded on page 295, para 19, was that in light of the aforesaid, this court is of the opinion that the order passed by the tribunal to run the plant and machinery, which is 22 years old and which is lying closed for the last 2 years, deserves to be quashed and is accordingly quashed. The directions given by the tribunal in paragraphs number 29 and 39 of the impugned order dated 22/1/2019, that was pronounced on the 6th February 2019, are quashed. However, the petitioner company shall continue to pay the workmen as per the agreement. So this is what led to continuation of their payment of wages. And for 4 years, they did not take any step to follow the ID Act section 25O. Otherwise, and the state government, we have a bunch of letters. We met every single official, minister, etc., and appealed to them, and also wrote to the Labour Commissioner office that you have to intervene because we don't want to become lazy, sit down and take the wages. This is what they would sometimes, accuse the workers of. But workers did not want to really keep sitting on the satyagraha, which was permitted by the tribunal's order, saying that they have a right to agitate because they continued the work in the sanctuary for years until they wear it to whom they had, but through the fake transfer they had transferred, till they took over, they were running the mills. So the real producers were our workers, and yet they were cheated in a way. And when this happened, we had to go to the Supreme Court. Now, Supreme Court order is here on page 305. But the only thing that is not annexed in this is the correction to that order. One word was wrongly typed, continued in the last paragraph. It's just 2-paragraph order. So the Supreme Court said that they will not interfere with the judgment passed by the High Court. But most important thing that the Supreme Court said is that any application filed by the respondent under section 25O of the Industrial Tribal Disputes Act 1947 shall be not continued, that is changed, that is changed to considered without being influenced by the observations made by the High Court on the viability of the unit. The undertaking given by the respondent regarding payment of wages shall be scrupulously complied with. So it was the apex court's order that they had to follow 25O, and till they did that, to continue the payment because it was illegal closure under the ID Act. Now, Your Lordship, when this was happening, and they did not follow all that, the Century was giving time and again through their applications before the tribunal kind of undertaking that we will always follow law and there will be nothing, no illegal step will be taken, etc., etc. That is the undertaking is in their application for withdrawal of the reference that was continuing till the stage of evidence, when they continued to say that it should be repealed, but tribunal did not accept it. But finally, the High Court accepted it. And because the reference was not filed when our union was there, but we were representing as 5 persons under under Rule 36, the workers, because 90% and more workers had joined us and they had resigned from all the unions. And what unions were doing, it's a long story. But our union, which is 1966 union, and it is registered in Maharashtra, but for all India operations. Now, every time when the company questioned it, finally, when we filed a complaint, and the labor officer asked for the guidance from the labor commissioner asked labor officer to approach the registrar of trade unions, and there is a clear statement by registrar that we can have the union in Century because ours is all India operation and we have everything up to date filed. Our audit, our general body meetings, and our union is very different from the rest.
Take to the issue.
Yes. Now, in that situation, Your Lordship, when the Supreme Court gave this order, after 4 years, during which they claimed that, oh, they were paying money and they had to pay crores of rupees. Why did they have to pay crores of rupees? Because they were not following law, and they had resorted to illegal closure of the mills. And their game is clear from their reports. But after that, suddenly on 29th of June, 2021, they just put a notice on the board, not even given to the individual workers. And that was for the sale of the mills, they said, but it was the sale of assets because the mills were closed. So they were not running the mills. And they said that in that notice, which is the 29th June notice, that the purchaser does not want to take in the workers, so we will only have the VRS as the option, and VRS will be given this much, 35 and 25 days of the years.
No, what is wrong in the impute order? You have only 10 minutes, 10 more minutes.
Yes, but now the main issue starts.
Yes.
Lord. And they said that under 25 FF, they were selling the assets. Now, they did not say assets, they said the mills. But we are claiming that those were the closed mills. That is mentioned even in the registrar of stamps, collector of stamps, this thing, the note sheets and the interim decisions, which clearly say that the mill to band hai. Or as I read the High Court judgment and the Century's affidavits filed before the High Court, it was very clear that the mills were closed and they did not follow the order. And we had therefore to decide whether VRS should be accepted. I just go back for one thing, which was cheating the workers, that these, officials, some of whom are present in this court, they had come for a dialogue and they came 4 times for the dialogue. Because the first time they came, there's vice president, they said, offered to me and Mr. Chauhan, our secretary was present, and one more worker, that, okay, if you do not want to accept VRS this much, which was coming to 4 lakhs or so, then we will give you the 2 mills. And because you are there, we are giving this offer. For 1 rupee, we will give you the mills. I said, what is it? It's our dream that the workers will become the owners of the property which is come out of their sweat and blood. So, but we said, no, we will discuss both the options. And they filed an affidavit before the tribunal giving these 2 options, my lord. And and they continued dialogue with us 4 times, even in the Radisson Hotel and 5-star hotels, etc. But suddenly what happened? When we prepared the whole thing and the proposal and we submitted it, so not that we did not plan anything, we planned it carefully and we were wanting them to become the advisors and be on the board also. But suddenly the rest of the unions who did not even have 15% of membership, so under Trade Union Act, they had no negotiating powers. And this is what was accepted by the Vice President on the 25th of February, when our people met there. I was suffering of corona, but they went to meet.
Just confine yourself to the fact that what
Yes,
is wrong,
so
with,
the fact is,
wrong with the impugned order. What
so
is
the
wrong?
fact is that the 25 FF that they resorted to was only to avoid 25O. And they withdrew their own offer of giving the 2 mills to the cooperative body of the workers. This is what I wanted to say. Now, after this, you know, Your Lordship, that we approached this honorable court. And then Your Lordship gave a judgment, which is the 11885.
Page number?
It is page number 70 onwards. And it was very clearly mentioned. Of course, the decision was that the High Court cannot deal with anything related to the private company under Article 226. We didn't mind that. But it was very clearly stated that para 8, for example, that there is an efficacious alternative remedy under ID Act. And that is what was accepted by the council for the respondents. That is the main this thing. So it is stated in para 8, page 73.
What happened thereafter?
No, so the judgment by this honorable court was clearly in favor of our approaching following the process under the Industrial Dispute Act. Para 22, 23, whoever the petitioners are at liberty to take recourse to such legal remedies as are available to them under law. And in such circumstances, this court finds force with the contention raised by C.U. Singh ji, who was their counsel, that the petition is filed despite having efficacious alternative statutory remedy available to the petitioners under the provisions of Industrial Disputes Act. Now, when we filed this, the order that came without any conciliation meeting with the chief conciliator, the labor commissioner, the office, which in many cases we know is not following the legal procedure at all, not even responding to our this thing. In between also we had filed a complaint. It never reached a logical end in spite of some conciliation meeting that had taken place in Khargon and the guidance that was asked for by the labor officer to the chief conciliator, who is the labor commissioner. Now, I can submit all the documents with the written submission if you suggest so. Now, this order of the commissioner, labor commissioner, from 48, page 48 to page 68, rejected and said that there is no dispute at all. Now, the definition under 2K, section 2K of the ID Act, everyone knows is very, very wide. And any dispute between difference of opinion between employer and employer, or employer and employee, or employee and employee, must be considered as an industrial dispute. And it is for the peace and harmony in the industrial area that this act came into being in 1947. आज आजादी के महोत्सव हम मना रहे हैं तो इस कानून का भी सलाम करते हैं, पर when it is this that they had to really follow, they are not following this act, and the powers that are given to the conciliator, the labor commissioner, is the administrative power, not the judicial or quasi-judicial powers. And that is there in many, many judgments. I want to at least submit a set of judgments which can be referred to if there is time, but otherwise I can just give a set of judgments. That is no problem. Now, in the judgment of Jilla Satna, Cement Steel Foundry, Khadan Kamgar Union versus Union, this very honorable court had given an order in 2018, and that also makes it very, very clear that 2K, page 4, the big numbers are the page numbers of ours. The 2K, industrial dispute means any dispute or difference between employers and employers, or between employers and workmen, or between workmen and workmen, which is connected with the employment or non-employment, or the terms of employment, or with the conditions of labor of any person. Now, this any person is also discussed and debated in many judgments. I will not go into that. But this is what. Again, the 10, section 10, under which we filed this complaint for the reference for conciliation, and if the conciliation fails, the reference to the tribunal. Again, it says that where the reference of disputes to boards, courts, or tribunals, where the appropriate government is of opinion that any industrial dispute exists or is apprehended, it may at any time by order in writing refer any matter appearing to be connected with or relevant to the dispute to a court for inquiry. Now, rejecting this without the proper and justifiable reasoning is something that we want to accuse the Labour Commissioner's office of, because it is very clear that the function of the appropriate government, para 13 on page 6, is an administrative function and not a judicial or quasi-judicial function. How can they, without even asking for the evidence, come to a conclusion that there is no dispute? There is such a major dispute, and the legal basis are the various orders up to the apex court's order. They cannot reject this. And this is what your own Honorable High Court's judgment, my Lord, has clearly stated. And also there was then an appeal before the divisional bench, which is the P4 in the first index, that is 746. And that clearly is stating many things. It begins from page 92 onwards, and it is very clear that pardon? 82, yeah. And it becomes very clear. Here also the page 86, para 6, Your Lordship, that Shri C.U. Singh, Learned Senior Counsel, submits that earlier interference was made by this court arising out of a reference made under section 10 of ID Act, mainly on the ground that a contract was entered into by employer with Very Global without paying the stamp duty and fulfilling other statutory. In addition, the agreement entered into between the union and respondents were not taken care of by placing reliance on conditions, etc. Now, again, he also said Thus, argument of non-availability of remedy under ID Act was vehemently opposed. That there is the remedy under ID Act. This is what was the order of this bench, single bench, and also the endorsed by the division bench. And when this was the situation, we thought that the labor commissioner, the conciliator, has to take the lead and then refer our this thing. Now the reply that they have given is concentrating only on one thing, that we have challenged the transaction under 25 FF, but they are not saying clearly that our main dispute is that without following 25O, they have resorted to 25 FF, avoiding that whole procedure of seeking the consent of the state government. They are only referring to the stamp duty. It is true that we questioned it and we are still in the process of challenging it, because there is a big fraud that has taken place even in this second transaction, where the assets are valued worth 62 crores. Again, when the original assessment, which they had not questioned in any High Court judgment, High Court pleadings, was 426 crores. And again, now they have showed this property to be 62 crores. Another thing is that the mills were not running, but in their registry, I had brought some copies, but you don't want the documents. I will only say that the registry clearly mentions that it is it clearly mentions that the mills are running, and that is manufacturing, marketing, everything is going on. So showing that it is the running business that they have sold under 25 FF. This is again a fraudulent and non-genuine claim. And that is why the vendor, through its various divisions, is involved in the business of manufacturing of cement, pulp and paper, cotton, textile, among others, and is also engaged in manufacturing, distribution, and sale of yarn and denim through its yarn and denim units situated at village and post Satrati. Now, there are many other objections that we have taken about the property related to each of the two mills, the location of each of the two mills, etc., etc., whether the buildings are all RBC or RCC, etc. And there are a number of other things which we can prove through our this thing, but this is not to be placed before this court. And the labor commissioner also has no judicial powers to really go into this, and we did not want them to go into this. Our main dispute is that they have resorted to illegal closure for 4 years, when the state government also should have interfered and played their role. And next, again, the cell under 25 FF. We want all of this to be really reviewed, assessed with evidence by the industrial tribunal, which is the only resort to the workers need this thing. So, Your Lordship, I think we can provide all evidence, etc. But when all these judgments, if you want, I can read one or two judgments.
There is no necessity to read.
No need?
Yeah.
Okay.
Time is also up.
But the point is that whether it is the judgment by Justice Gopala Gowda or the Ram Avatar Sharma's case, there are 3-4 cases where it is very, very clear. It is very clear that this labor commissioner's office has exceeded their.
I will go through those judgments.
Okay.
Yeah.
And that is why, if this happens, then the workers in this state, which are really suffering in every single industry in our area, will not ever get any channel to get the real response. And there was no conciliation meeting called, and earlier complaint, there was no logical end reached. And again, this is also they want to reject. So we filed this thing. Even the reply by the Century that questions the locus standi of the union is absolutely ill-based. And the Centuries reply have number of points which we have responded to through our rejoinder, and reply affidavit filed by the Assistant Labour Commissioner also does not really mention this whole history that I gave related to the High Court order and the Supreme Court order. And escaping that, they are defending everything that has happened, showing it to be illegal, while everything is illegal and the workers are made to suffer. And only because this honorable court could not hear us, the 29 months they are without payment. Now they are saying that they have paid, they put the one-sided decision taken and amount paid in the accounts, but that is only based on the 25F. So it is the 15 days, the gratuity, and they had to pay for 3 months salary because they had not given 3 months notice. So again, it was the illegality that led them to pay. They cannot, they have become generous and they have served the workers. And in this situation, getting 2 lakhs to 4 lakhs, workers cannot have the whole life with the children studying computer science, engineering, etc. The institutions needing 70,000, 90,000.
That's all. That's all.
So,
Yes, Mr. Director.
we
Yeah.
want this to be really done justice to.
Yes.
Thank you.